So the way we'll proceed is, appellant, you may reserve up to 5 minutes of your time, 15 minutes, and the appellee will have 15 minutes. You can address both sides of your argument at that time. You should be aware that we do record and post the videos on our YouTube channel, so we ask that you remain at the front podium and keep your voice up so we can get a good recording on that. And I can tell you the court has read the briefs in the matter and are prepared to proceed if you are.
Thank you.
Thank you.
May it please the court, my name is Jennifer Flint of Bricker and Eckler. I represent the appellant, the Lorain County Joint Vocational School District Board of Education. I would like to reserve, I'm estimating about 3 minutes for rebuttal.
All right, I'll try to let you know when you get close.
Okay, thank you, Your Honor. This case centers on a contract that was executed by the City of Oberlin and the Lorain County JVS back in 1971. The essential issues on appeal are, one, is the contract void for lack of a fiscal certificate? If it's not void, and the contract is valid and enforceable, then do the terms of the contract obligate the JVS to sign an expedited Type 1 annexation petition that was presented to the JVS by Oberlin in 2014? And third, does the contract prohibit the JVS from ever seeking annexation on its own volition without it having to have been initiated by the City of Oberlin? As to the first issue, whether the contract is void for lack of a fiscal certificate, when the contract was executed in 1971, the revised code section at issue is 5705.41. It mandated what is still required today, and that is if a political subdivision makes a contract involving the expenditure of money, it must attach to the contract a fiscal certificate. And if the contract does not attach a fiscal certificate, then the contract is void. Both the Ohio Supreme Court and this court, and actually many other courts, have held that a fiscal certificate is actually a prerequisite to a valid contract.
But isn't the purpose of the fiscal certificate to require the entity to allocate a certain amount of funds to pay for that contract? That's the whole purpose of it, right?
That is the purpose of it,
Okay.
Absolutely, Your Honor.
And the contract in this case, did it have a specific amount that the JVS was supposed to spend?
The contract itself did not specify a specific amount, and I don't believe that the case law says that it has to specify a certain amount.
Was a subsequent contract entered into between the JVS and the company that actually did the construction work?
No, the contract was, I don't know if there was a contract entered into between the construction contractor or any of the political subdivisions here. The contract, but there's no question that the contract here between the JVS and Oberlin involved the expenditure of money. It
But no
obligated,
specific amount.
exactly. However, it's undisputed in the record that the very same day, it's in the same minutes, the JVS board minutes, that this contract was approved by the Board of Education, they authorized their clerk to pay Oberlin a very specific amount, $103,232.11, same night they approved this contract. Why? Because that was the JVS's share of the construction costs, which both parties were aware of at that time. So there's no question that the fiscal officer of the JVS could, at this time, have issued a fiscal certificate for this contract. They knew the amount at that time.
Was that money actually ever spent by the JVS, or was it supposed to be reimbursed by the City of Oberlin?
That amount was spent by the JVS. The check, I think, was issued within weeks of that date. And in fact, more was spent. It's not unusual that, construction jobs, they cost more, and there were some additional expenses that were paid by the JVS. The total amount paid, and I think it was all paid in 1971, was around $127,000.
Is there a difference
Directly to Oberlin.
between contracting with non-governmental entities as opposed to contracting with sister governmental entities? Is there a difference between the contract?
There isn't, and
and
there
the one?
certainly is no exception in the revised code
Statute.
section at issue. It says, no political subdivision, when making a contract, when making any contract for the expenditure of money, so it's any contract. I know that there was a case cited by Oberlin where a court, I think it's back in the very early 80s, where one court of appeals found that it wasn't necessary, although I do think that case turned more on issues of fairness on political subdivisions, constituents having to pay, but we don't have that issue here, because the JDS did in fact pay the full amount of its obligations under the contract in terms of construction costs. It was the vast majority, in fact, of the costs of the construction of the sewer line. And so, there's no question, but at the time this contract was approved by the JVS board, that there was an amount certain that was known to be the JVS's share, and in fact that was authorized by its clerk to be paid to the city of Oberlin. And I think that's why this case is not on point with the Grand Valley case, which both the trial court and Oberlin relied on. The facts are completely different. Grand Valley, first of all, does not hold that a fiscal certificate is only required when the contract includes a specific expenditure of funds. And in fact, the reason a fiscal certificate, the court found in that case, as the 10th district, that no fiscal certificate was required is because unlike the contract here, the contract in Grand Valley, by its very terms, did not obligate the Board of Education there to expend any funds at all.
So essentially, although the statute puts a requirement on the treasurer to issue the certificate, it really puts the burden on the contractor to make sure the certificate gets issued before they even bother to do anything.
It absolutely does. If I'm a contractor and I want that contract to be valid and enforceable, I should know the law and want to make sure that a fiscal certificate is issued with any contract involving the expenditure of funds. Absolutely. So I believe the salient question to ask in determining whether or not a fiscal certificate is required is, does the contract involve the government's expenditure of money? If it obligates the political subdivision to expend money, it requires a fiscal certificate. Under the trial court's logic, a political subdivision could avoid the fiscal certificate requirement simply by omitting from the contract the specific amount of money that's required, that the government's obligated to spend. That's not what 570541 says. Because the contract here unequivocally obligated actually both political subdivisions to expend funds, then the contract required a fiscal certificate. And the JDS respectfully believes that the trial court erred in concluding otherwise, and would ask that the court sustain the JDS's first assignment of error. But assuming that this court does not sustain the first assignment of error and the contract is found to be valid and enforceable, then we really get to the central dispute between the parties in this case.
Can we just go back once? Can you address the argument that JDS never questioned the validity of the contract for 40-some years, and what effect that has?
Well, I don't know, I was around in 1971, but I don't know that they ever questioned it. I don't know if they ever questioned the validity or not until this arose. I think the JVS was being constructed at that time, and there were issues, I think, between both parties separately on issues relating to sewer systems. And the JVS needed to be built, and they had added, I think, maybe 9 schools in the year before they actually opened, and so they needed to open that school. And I think both parties were helping each other out, entered into this contract, got the sewer line built, the JVS was built, and nobody thought about this again for decades. Under the contract, for example, Oberlin was supposed to be keeping an accounting of all the tap-in fees that they collected, because, you know, it wasn't just the JVS sewer line. It was Oberlin sewer line, actually, and other folks could tap into it, and under the contract, in fact, the majority of this contract was all about the sewer line and tap-in fees. So I think both parties frankly forgot about it. Oberlin didn't even keep an accounting of the tap-in fees, and until the property, the JVS property became contiguous and could be annexed, that's when this all came to pass in terms of this contract from 1971.
You've got about 2.5 minutes, still your 3 minutes.
Okay, well, I'll try to be real quick about, again, the central dispute between the parties is about annexation. And it stems from a singular provision in that 1971 contract. It's paragraph 10 that, I'll quote it, "School further agrees to sign an annexation petition for their property if presented to them." Again, this is 1971. We fast forward 43 years later, in August of 2014, Oberlin presents the JVS with what's a purported expedited type 1 annexation petition and demands the JVS sign it. When the JVS would not sign it, Oberlin sued the JVS for breach of contract. They claim the JVS is contractually obligated under this contract to sign this expedited type 1 annexation petition, and they rely on paragraph 10 of this 1971 agreement in support of that position. The problem with that argument is that the trial court actually got this right, is that the parties did not, because they could not have agreed in 1971 that the JVS would sign an expedited type 1 annexation petition. Why? Because there was no such thing as expedited annexation in 1971. Annexation in 1971, just as it is today, it is a process that's governed strictly by statute. It's in Revised Code, Chapter 709. It's well-established Ohio State Supreme Court case law that when parties enter into a contract, the laws that exist at the time and place of the making of that contract enter into and they form a part of the contract as if they were expressly referenced in that contract. So when the sewer contract was entered into here in 1971, there was only one type of annexation. There's only one way owners could seek annexation of their property, and that's by way of the traditional annexation, which we still have today. It requires at least 51% of the majority, 51% of owners in the territory proposed for annexation have to sign it.
All right, Attorney Flynn, I just want to let you know you're at your 3 minutes. Now
Okay.
you can continue, or?
I'll say a couple minutes.
All right, so
Thank
we'll
you.
say 3 minutes for your rebuttal. Thank you. All right, counsel, you're going to have 15 minutes to address.
Thank you, Your
both
Honor.
sides of the issue.
May it please the court. My name is Dennis O'Toole. I was around 48 years ago. My wife reminded me this morning, it was around St. Patrick's Day 45 years ago that I made my first argument in front of Judge Mahoney, the 9th District Court of Appeals. Judge Schaefer, to address the questions that you had and to give you a proper answer, if you look at the agreement that was signed in 1971, the agreement is 2 simple pages. In several sections, for example, in the last whereas, it says the school is interested in arranging for sanitary sewer services for said school building, and the city is willing to have said school tied into the existing sanitary sewer system under certain conditions. The agreement, particularly notably paragraph 4, says when construction bids have been received, they had not been received. Both city and school shall review them, and if they are acceptable to both parties, city shall award the contract, the cost of said contract be paid as follows. Well, how are you going to have a fiscal certificate signed in 1971 if you don't know the estimates, you don't know the cost, and neither party has approved them? the purpose of a fiscal certificate is to certify that the contract that you're entering into for a defined sum of money, there are funds available to pay those. This was a situation which is exactly like the one in Grand Valley, which we cited in the brief, which said there was a memorandum of understanding which defined the responsibilities between the parties, but did not deal with specific dollar amounts. The most important part, and one of the reasons why I'm standing here today, is the trial court's error from our standpoint in not finding that the JVS breached the contract by refusing to sign the expedited petition. I am willing to admit, for the record, that in 1971, the Ohio Revised Code did not provide for an expedited Type 1 or Type 2 annexation. It was not in existence.
The type of annexation thing that was in existence at the time, which wasn't a Type 1 or a Type 2,
That's correct, Your
did
Honor.
that require the people who live on that land that's being annexed to pay taxes to the annexing entity?
Yes, Your Honor.
So there was no opportunity for the employees of the JVS to not have to pay. This is what really just this is all about, right?
Exactly, Your Honor. It's all about a handful of employees at JVS that don't want to pay any tax. But in 1971, the city of Oberlin had a policy. The policy was, you don't get services unless you annex. That was their policy. Now, the JVS, if you drive out on Route 58 and go past Route 10, you're going to see this huge monolithic building on this 133-acre campus. That's the JVS building that was begun back in the early 1970s. The problem became is that they were going to put in their own sanitary sewer system. The problem is that it violated both state and federal law. How did it do that? Because the effluent, the discharge, would have been less than 3 miles from the intake of the city of Oberlin's water intake facilities and reservoir. So they could not build it unless they had some new arrangement. The new arrangement had to be, we need to have our effluent, our sanitary waste, treated by the city of Oberlin. And Oberlin made an exception to the policy because of the exigent circumstances. They came up with this agreement in paragraph number 10 in this agreement. What does it say? Real simple. Could it be better? Probably. But here's what it says, Your Honors. School further agrees to sign an annexation petition for the property it presented to them. Please allow me to repeat that one more time. School further agrees to sign an annexation petition for the property if presented to them. The intent of the parties, Your Honors, was that JVS, to get these services, was going to have to annex. Annex now? No, they couldn't annex now. They were contiguous to the city. So it was in the future. It was the intent of the parties that sometime in the future, when Oberlin presented JVS with an annexation petition, JVS would sign that petition. And what is the closest model to that? Because there is no 1971 traditional annexation process. It's exactly the same as the one that exists today. But if the intent of the parties, and if you look at the record, if you look at Mr. Dalton's deposition and his affidavit, he did a memo to the file back in 1975 that outlined what the reasoning was for the exception to the policy, that there were exigent circumstances, that the JVS needed these services, and that Oberlin, despite its policy of never allowing annexation without, or never providing services without annexation, they made an exception in this one case, a case that has never been violated since. They've never made another exception. So the intent of the parties was, when this land becomes contiguous, we're going to present you with a petition to annex. The intent of the parties being, you're going to annex. It's just that simple. So the fact that the law changed, the intellectual exercise ought to be, well, was the petition that was presented most in keeping with the intent of the parties at the time? And the expedited one that was presented, not in existence back in 1971, admittedly, but was most like and consistent with the intent of the parties. There cannot be any argument today, and if you look at, I get so confused by this that I found the Ohio State Legislature actually has a treatise. It's called Final Summary Analysis of Senate Bill 5. It's online. It shows the differences between what was pre-existing before the change in 2001 to 2002.
But is that part of our record?
Yeah.
Is that part of our record?
It
What
is
you're
not.
referring to?
It is not
Okay.
part of the record, I'm sorry. That's a good point. What is part of the record is that during this period of time, when the president of the JVS board was deposed and was asked the question, why did you not agree to the type 1 expedited petition? Her answer was, I don't know. When she was asked, why did you reject the requests of the city of Oberlin to annex, and in 2013 adopt a resolution that stated the reason was it wasn't contiguous? Well, it actually was contiguous as far back in 2006. However, here's the key. She said there was another reason why we didn't want to do it, and that's because the employees of the JVS, a handful of employees, would be very upset if we allowed this, and they would be taxed. They would be subject to income tax. That's why we're here. And that's why the trial court got all caught up in this. You have to do you can't do type 1, it has to be the traditional. Well, the traditional that existed in 1971 is not the same as it is now. So that's not a good argument. What the trial court failed to do, they failed to follow the intent of the parties. What was the intent of the parties? And after 48 years, Judge Theodosio, as you pointed out, after 48 years, we now have one party who's had full advantage to have all of their sewage treated, updated treatment facilities, all of the amenities of being in the city without having to pay anything for it. All of that after 48 years, and they now bring up fiscal certificates and the vagueness of the agreement, not understanding why they would reject this. If you read the deposition of the superintendent, Glenn Faircloth, it's embarrassing, Your Honor, the reasons why they give for not following this agreement and signing the petition. And I'm telling the court, as surely as night follows day, the argument presented by JVS is this. This agreement only provides that we have to sign an annexation petition when presented to us. Okay? You know what happens next? They're going to withdraw their signature. They're not going to agree to annexation this court orders. That's what the 71 agreement was for. It was to require annexation when the city of Oberlin presented to JVS a petition to annex. JVS has consistently, from the very first time that Oberlin presented them with a petition to annex, including the traditional petition as it exists today, JVS has refused to sign it. And if they sign the petition, mark my words, they will withdraw their signature as permitted by statute. And that was never the intent back in 1971 between the parties. Put it another way, do you think that the city of Oberlin would have provided sanitary sewer services if the annexation process had to happen first? And JVS either couldn't get it annexed or refused to it? What would the city of Oberlin do? I'll tell you what the city of Oberlin would have done. You would not have gotten sanitary sewer services because that was the deal. JVS wants to make this so complex and so obtuse and so into the weeds when really it's just this court going back. And what this court stands for, what you always stood for, is the sanctity of a contractual agreement, the ability to look at the intent of the parties at the time that they entered into the agreement. And to do anything else says that this district no longer stands for the sanctity of a contract freely and willingly entered into by political subdivisions. Political subdivisions, both political subdivisions, who have a mandatory duty. When you read President Melba's deposition, she admits that she did not know that there was a benefit to the district, a financial benefit to the district to belong and to be annexed to the city of Oberlin. She didn't know that. She had never been presented that. But there's the treasurer and the auditor who both gave depositions that said, we had spreadsheets for them. I asked the president of the board, did you ever see the spreadsheet that showed all the benefits that you get? No. Well, why wouldn't you agree to this? Because a handful of employees don't want to pay income tax. That's why. And all of this is just a smokescreen for that, Your Honors. That's all this is. I appreciate your time.
Let me see if there's any questions, Attorney Jewell, Counsel, good shaver. I guess not. Thank you for your argument. And Attorney Flint, you'll have 3 minutes for your rebuttal.
Thank you. First of all, I need to address, there's many things that Mr. O'Toole said that are not in the record. Certainly, he did not cite to anything in the record. Certainly, this offhand comment that, mark my words, if they are required to sign a traditional type annexation petition, they'll withdraw their signature. That's nowhere in the record. That's the first time I've ever heard that. So I do ask that you disregard any statements that are not in the record, and just purely Mr. O'Toole's opinion. One thing that Mr. O'Toole repeatedly said was, what's the intent of the parties? What's the intent of the parties? And the expedited type 1 annexation is the closest to the intent of the parties. Well, of course it wasn't. It couldn't have been in their minds because it didn't exist. What was the intent of the parties? What was in their minds? The traditional type annexation petition, the one that existed. And it still exists today, and it is virtually the same process, substantively, as it was in 1971.
Is it exactly the same as it was in 1971?
It is not exactly the same.
Is type 1 exactly the same?
Pardon me?
Type 1 isn't exactly the same, and type 2 isn't exactly the same.
None of the expedited annexation processes are the same. They're not even close to being the same. That's the reason why the legislature actually put them in March of 2002, because it's when 100% of the owners agreed to sign the annexation petition. They're called expedited for a reason. They're called expedited because first of all, when you sign an expedited type 1 or type 2 annexation petition, it has to have in bold, all caps, you as a signer, as an owner, are waiving your right to appeal the county commissioner's decision. And completely unlike the traditional type annexation process, the county commissioners have virtually no discretion when they review an expedited type 1 or 2 annexation petition. They have to approve it if certain technical requirements are met.
Is it your contention that because there is no traditional one anymore, there's just a type 1 or type 2, that you can't annex at all?
Actually, not at all.
So that's not your position at all?
No.
Okay.
The traditional type annexation process absolutely still exists today.
Okay.
In
So
fact,
that's-
what I'm saying is it's virtually the same process that existed in
I'm not talking about the
1971.
process, I'm talking about the end result. Is the end result the same? I don't care about the process. In the end result, they're going to be annexed, right?
Assuming that it goes through the process and the county commissioners want to approve the annexation, which they have to do with all types of annexation. And then, with a traditional type annexation, they have discretion, there's a lot more you're looking at. So it could be that the county commissioners don't approve a traditional type annexation. They have discretion to not approve it, and that all could be appealed through the court system. With expedited type 1, if certain technical requirements are met, the county commissioners approve. But here's another key point that needs to be understood.
Because we're out
Pardon?
of time. So make it a very short
Okay.
point because you're out of time.
I was gonna say that filing an annexation petition, even the county commissioners approving an annexation petition does not equal annexation.
Okay, thank you.
Thank you both for your arguments. Very interesting case. The court will obviously get into the record in this case and issue a decision in due course. Once we do reach our decision and it's filed at clerk of courts, we'll certainly mail you both a copy of the decision on the day it's released. I should note that the opinions are also posted on the Supreme Court of Ohio's websites, but again, thank you both for your arguments.
Thank you, Your Honor.